everybody, and welcome to another episode of LJ Law, Family Law TV. I am Bonnie Leonardo, your host. Today's topic deals with not being happy with the decision that was made by a judge on your case and being able to appeal that decision. Before I get started with that, I want to remind you that if you have questions about this topic or any other family law topic, please don't hesitate and go to vegasdivorcemeeting.com. I'll be more than happy to sit down with you to discuss your particular situation. So the question comes from Elizabeth, and she went to court, she went to trial, and she was not happy with the decision that the court made. She felt like the judge was biased against her and her case. She wanted to know if she had a recourse and if she could appeal the judge's decision. I explained to her that yes, you have a legal right to appeal a decision from a judge that you feel was not correct or in your best interest. When you appeal, when you make an appeal, that usually goes to the Nevada Supreme Court, and the Nevada Supreme Court then can assign a case to the Court of Appeals or handle them themselves. It usually is not done, the appeal is not done with the judge that rendered the original decision. When you appeal a decision, it is reviewed by a higher court. Like I said, the appeals court, they will look at the evidence that was presented to the trial court to decide whether some legal error was made. I want to be clear that you understand that, to make sure that a legal error was made. Not that the decision that was made was a decision that was against you, you weren't happy with it, and therefore you want another bite of the apple, so to speak. It has to be something that was legally wrong, something that the court, the judge originally making the decision did wrong. You won't be able to submit new evidence. The appeals judge will only look at what you submitted to the trial judge. So it's the same information, nothing new can come in. And depending on what the appeals court decides, the decision can either be set aside, it can be confirmed, or it can modify the trial court's judgment. I can even make a new trial, an order for a new trial. What I want you to know is that there are three reasons basically why you want to appeal. One, the judge made an error of law, like I explained. Two, the evidence and the facts did not support the decision that the judge came with. And three, the judge could have abused his or her power in making the decision during the trial. Remember that appeals are complicated, they are expensive, they are lengthy. So you do not want to file an appeal simply because you were unhappy with the results of the trial and the ruling. Remember that prior to filing an appeal. I hope this has answered your question, Elizabeth. If you want more clarification on this, please go to vegasdivorcemeeting.com. I'll sit down with you and discuss this further. And if you like the video, please hit the like button. If you know somebody who can benefit from this information, please share this video with them. And as always, I want to thank you for tuning in, and I will see you next time.